Hello, everyone. Thank you for joining us today. This is Abby from Tribal Law and Policy Institute. Sorry for the delay this afternoon. I would like to go over some quick tips before we begin today's webinar. I know most of you have attended past webinars and are already familiar with the control panel on your right, but here are just a few reminders. Your control panel will show on your user screen. All attendees will be muted during the presentation. And once you call into the meeting line, enter your PIN. Use the question box on the control panel to submit questions and responses. To minimize, use the orange arrow on the top left and see the handout section for documents referenced in this webinar. Today's webinar is hosted by the Strengthening Tribal Response to Violence Against Native Women and is part of our Legal Resource Webinar series, the final part of the series, focusing on domestic violence courts and dockets with our presenter, Kelly Stoner, who's the Victim Advocacy Specialist with TLPI. And now I will turn it over to Lana Hunter to get us started.
Thank you, Abby. Hamatakiapi'e, Lana Hunter Makiapi'e, Sisiptawan ke Wakpetawan e Mataha. My name is Lana Hunter, and I'm from the Sisseton Wahpeton Oyate, Dakota Nation in Sisseton, South Dakota, and my father's people are from the Tlingit Nation. We welcome you here today to our webinar for the Strengthening Tribal Response to Violence Against Native Women series. We've actually had a series of 3 legal presentations, all done by our partners and or our tribal law and policy staff, such as today. We will be featuring Kelly Gaines Stoner as well as Chia, who will be on the call or on the webinar and joining us a little bit later. So the project that we are currently funded for with the Office on Violence Against Women is in partnership with a number of other agencies and organizations. So part of our strategy to provide training and technical assistance is really to understand how we provide training and technical assistance to tribes that do currently not receive Office on Violence Against Women funding. So that is the project. You can see and learn more about it at www.tribalresponse.org. So this is free training, again, to tribes who do not receive Violence Against Women funding. So the partnership that we have is to be in partnership with a number of other organizations who are national tribal training and technical assistance providers. So we work with the Tribal Judicial Institute at the University of North Dakota School of Law, and we work with them to understand that they provide training for us on tribal protection orders as they pertain to enforcement, as they pertain to legal codes within your tribal jurisdiction. So we have partnered with their law school to provide that resource. We also partner with the Alaska Native Women's Resource Center, and they are located in Fairbanks, Alaska. They are a partner to work with tribes in Alaska on developing a number of resources as well as training and technical assistance. And the other folks that we partner with are the Alliance of Tribal Coalitions to End Violence. So there are 18 tribal coalitions located throughout the United States. And we have partnered with the Alliance of Tribal Coalitions because they also provide training and technical assistance in those 18 states. And they also bring to this project shelter and safe home policies, procedures, sustaining, and also developing resources as well. And we also work with our organization, which is the Tribal Law and Policy Institute, and we form the Tribal Response to Strengthening Violence Against Native Women. We also work with direct service providers, and this is to inform our policies, to inform our training, And those organizations are the Great Seminole Nation of Oklahoma Domestic Violence Program, located in Seminole Nation, Oklahoma. We also work with the Amonic Women's Shelter in Amonic, Alaska. And we also partner with the Native Alliance Against Violence, which is a coalition, tribal coalition, as well as they provide shelter and programming for Native women and their children. So this project is funded, again, through the Office on Violence Against Women. And we just wanted to highlight that this is free training for those who do not receive Office on Violence Against Women funding. And this is pertaining to areas of domestic violence, sexual assault, stalking, and dating violence. So these are the areas that we can currently provide training in as they pertain to developing a coordinated community response, sexual assault response team, tribal protection orders, as well as shelter policies, procedures, sustaining and funding shelters for women and children who are seeking safety for violence. So this is just a little bit about our project, and we can share more at the end if you're interested in requesting training and technical assistance from a number of our folks who provide this service through the Strengthening Initiative. So at this time, I would like to turn this over to our presenter for today, Kelly Stoner. She actually works for the Tribal Law and Policy Institute. She's a victim advocacy legal specialist, attorney, and tribal judge. She comes from an extensive background dealing with tribal law and domestic violence, and she's a judge for the Seminole Nation of Oklahoma. And she helped to launch Oklahoma's only tribal coalition, which is the Native Alliance Against Violence, to respond to safety for Native women and children in Oklahoma. So Kelly, I will turn it over to you to talk to us today about tribal domestic violence, courts, and dockets.
Thank you, Lana, and welcome to everyone who is out there in internet land. Today's presentation is entitled, well, I can't get back to the original slide, perhaps creation of a tribal domestic violence court or docket. We're going to be moving through that. That's okay. You can just, that's all right. Just go back. There we go. Stick right there. But I wanted, before we get started, and Chia Halpern-Bizzo is also a co-presenter today. We've worked together for many years with the Tribal Law and Policy Institute, and Chia and myself and another one of our colleagues, Bonnie Claremont, worked very long and hard to develop a guide for the development of tribal victim-centered specialized court or docket to more effectively address domestic violence in Indian country. We're so pleased that that guide has been approved by the Office on Violence Against Women. It's available for free download at the TLPI address, which is www.home.tlpi.org. And I'll say it again, www.home.tlpi.org. And this presentation we're going to be doing today really draws heavily on this guide. And the guide was created to enable a tribe, any tribe, to pick the guide up and follow through the exercises. When the exercises, they're going to require you to do, answer some questions and bring in your tribal codes and a variety of other things that are necessary for you to evaluate whether a domestic violence court or docket would be helpful to your tribal community. So at the end of all these exercises, at the end, when the planning team has answered all the questions, you should have laid out before you beautifully whether a tribal domestic violence court or a tribal domestic violence docket is a good fit for your tribal community in the quest to address issues of domestic violence, sexual assault, and stalking in Indian country. So we're really proud of this. I'll give you a flavor of one of the exercises perhaps a little bit later, but I do want you to understand and to remember that the guide is a big piece of this curriculum. In addition to the guide, if you go to that web address I just gave you earlier, you will also find 3 slide decks that actually go with and complement the guide. You'll actually see 2 sets of the slide decks there. The first set does not contain any audio overlay. It's just the slides themselves. And that's really created for tribes or folks working on this that do not have good internet connection, just like me here today. So I'm just saying that we had those tribes in mind. So the first slide deck does not have audio overlay. The second slide deck you see, the second group of slides, still the same 3 PowerPoint slide decks, but each of these slides will have an audio overlay, and it's Bonnie, Chia, or myself narrating each slide so that you can get a group of people together working through these exercises, and you actually can bring Bonnie, Chia, and I into the meeting here via these audio overlays that we put on the slide. We also have available for you all 2 or 3 webinars that we've done on this very topic, that those webinars were recorded, and so those are available for you as well. Hopefully resource rich as you begin to mentor and think about whether a tribal DV court or a tribal DV docket would be a good fit for your tribe in this fight against domestic violence. So with that being said, I want to turn to the slide about the learning objectives. I always appreciate seeing these myself because it sort of lets me know what's coming up in the presentation. And at the end, you can look at these and see what type of job you think we did in actually giving you the answers to all these questions. So at the very end of the presentation, you should be able to compare and contrast key principles in a tribal domestic violence court or a tribal domestic violence docket. How are they the same? How are they different? You should also be able to identify the benefits and challenges of implementing a tribal domestic violence court or a tribal domestic violence docket. You should be able to identify core values. We're going to tell you what core values are, and so you're going to be able to identify those at the end of the presentation. And there are a slight difference in the core values in a tribal domestic violence court as opposed to a tribal domestic violence docket. We also want you to be able to explain the role of tribal custom and tradition in designing your tribal domestic violence court or tribal domestic violence docket, because one of the positions we take in the guide is if a tribe does not draw on customs and traditions and actually incorporate those belief systems into the development of this court or docket, that the chances of the court or docket surviving, having a long life in the community, is greatly reduced. So that's a very important issue to us. Next slide. So before we move into some examples of what a victim might actually need in a civil court and a criminal court, to give you some flavor of the types of relief that a victim might be coming into the court asking for, I want to just back up for a moment, and I want to touch on tribal sovereignty and how tribal sovereignty is boosted and enhanced, implemented, if you will, through the creation of a tribal domestic violence court or docket. And for those of you who may be new to Indian country, I just wanted to define for you generally what tribal sovereignty means. And it really means, at a general level, the power to make your own laws. So it's the tribal government's power to make laws and to govern with those laws, using those laws, every person that comes within their Indian country. For a reservation tribe, that may be within the exterior boundaries of your reservation. If you're not a reservation demolition tribe, it could mean trust lands. In Oklahoma, we would call them, or restricted allotted lands, pieces of land that the federal government is holding legal title to, or has put some restrictions on a tribe's ability to alienate those pieces of property. So tribal sovereignty, that's the essence of it. And it has many parts to it. So the part we're going to be talking about today is the part of judicial sovereignty. In this large concept of tribal sovereignty, the tribal courts play a very critical part in making sure, either by civil laws or criminal laws, that activities of all persons within Indian country are acceptable. And I mean acceptable by tribal law. So the tribal government is really sort of implementing these statutes that regulate what is acceptable and is not acceptable behavior in Indian country. So tribal courts are going to play a key role in exercising maximum tribal sovereignty. So let's stop there and pivot to, okay, if we have a tribal court, what kinds of cases, what kinds of relief might a victim need? And in civil court, it could be things like coming in and asking for a protection order from the tribal court, coming in saying to the tribal court, according to tribal law, I'm entitled to this sort of protection. And I'm going to ask the court to issue a protection order that commands the perpetrator to do or stop doing certain acts and to behave in a certain way. Also, going along with that is protection order enforcement. That occurs when the tribal court issues a protection order and it's the commands of the court are violated by the perpetrator. And the tribal court can enforce that protection order either civilly, through fines, through perhaps the civil contempt power, or the tribal court can punish the perpetrator in criminal ways, generally. And we can talk about that a little more later as well. So also employment law. The victim may come in and say, I can't go to work. I've had to miss. I've been in the hospital. I've been sick. I've been having some mental health issues because of all the abuse, and I haven't been able to come to work, and they've been fired from their job. Perhaps, according to tribal law, there was an exception for that, or the absences should have been excused under the employee handbook. And so employment law might be a civil remedy. Housing law, if the victim's been evicted or is threatening to be evicted from tribal housing, may need help with that. Debtor creditor relief. The victim may be in financial trouble because the perp has taken all the money. That is one of the spokes of the power and control wheel many of you know about. That's one of the methods that a perpetrator will use to maintain power and control over a victim, is taking all the money. So the victim may need some help with that as well. Bills need to be paid. Family law would be the kind of case where the tribal court is hearing a divorce or maybe addressing a custody matter and domestic violence is present in the case. Child welfare will arise civilly and or criminally, or maybe both. In the scenario where a victim has had her children removed, or they're threatened to be removed, perhaps by the state social services department, or perhaps by tribal Indian child welfare. Next slide. Examples of criminal relief that a victim might be coming in, and I made this very specific to when the perpetrator is the one who is charged with a domestic violence crime. These would be the remedies you might see a victim asking for. Perhaps she needs a criminal protection order limiting the perpetrator's contact with her, or coming in close proximity to her during the criminal case. And so that would be the role of the prosecutor, to step up and request that, but that might be something the victim is needing. Also, if the perpetrator's been charged with a crime, if the tribal code, their set of laws, have victims' rights in place, the victims are generally provided some rights along as this criminal case progresses. There's many rights available. You can find these rights. Those of you who are out there in internet land might want to be taking a few notes here, and because I'm going to be providing you some websites, and they may be also included in the additional resources, but I just want to make sure. You will find victims' rights at victimlaw.org, www.victimlaw.org. And the neat thing about that particular website is it contains every victim right tribal statute that has been made available in electronic form on the web. So very important that you use that as a resource as well if you haven't implemented victims' rights in your tribal code and you're interested in doing so. The last provision I have here is called an immunity provision. This also would be the role of the prosecutor, but again, the victim probably needs to request it. An immunity provision can take many forms, but generally that's going to be used in cases where the victim is called to testify, and in order to testify in the criminal case against the perpetrator, the victim may incriminate herself in some sort of criminal behavior. And this would be an agreement between the victim and the prosecutor that the victim will not be prosecuted if she discloses something of that nature. So just to kind of give you a general idea what all of those pieces mean. Next slide. So let's move on. Now that we have a little bit of background, knowing what kinds of relief the victim might need, and also referencing how important a tribal domestic violence court or docket is to the overall concept of tribal sovereignty. Note that tribal domestic violence court, let's get everybody focused there. What is that? What would that look like? And I'm here to tell you, as you follow through the guide that I mentioned earlier, it can be almost anything you need it to be. You can tailor it to meet the needs of your tribal community. And if you get going and you discover that you want to expand it to hear certain, maybe different kinds of cases, you can do that as well later. So this tribal domestic violence court, again, you're going to decide through these exercises, if we choose this court, do we want it to hear civil cases, sort of providing the relief that we mentioned in that earlier slide, the types of civil relief a victim might need? Or do we want it to be hearing criminal cases that involve domestic violence? Or do we want it to hear every type of case that involves domestic violence? Because one of the premises in the guide is that domestic violence cases are complex and they are dangerous. And there's a whole list of research that supports that particular statement. They're complex because victims need certain types of service providing that respects and acknowledges the safety issues involved. And also they're dangerous because of the safety issues that are involved and the lethality issues that are involved. So just to make that clear. So also a tribal domestic violence court, we kind of already have gone over this, allows, and it should require, incorporation of unique tribal customs and traditions with respect to what does the tribe believe is a healthy family looks like. And what role does the mother or the woman play in that healthy family? What does a child need to be in a healthy family? So you would explore through these exercises those sorts of concepts. It also allows, because it is a specialized court, it allows the tribal court in their DV court to implement policies, protocols, and trainings for particular personnel. That would include service personnel, law enforcement, probation, victim advocate that comes in contact with this family as the family makes their journey through the tribal domestic violence court systems. You will also, I believe, build stronger partner relationships among service providers. The tribal domestic violence court really envisions a core group, we call it the core case team, coming into each hearing and working together towards victim safety and batterer accountability. So it's going to get a lot of service providers on the same page, agreeing to certain protocols. Next slide. So here are the earmarks, some core case values, if you will, that tribal domestic violence courts will contain. And I will just tell you a short story here. As Chia and Bonnie and I began our research trying to locate a tribal domestic violence court that met these earmarks, we experienced some difficulty there because, and it doesn't mean there's not a tribal domestic violence court out there, it just means that we were not able to make contact with one. Because what we really saw was when some of the tribes implemented their specialized approach to domestic violence in Indian country, what we saw was more of a tribal domestic violence docket as opposed to a tribal domestic violence court. And we're going to go through, tease the differences out here in a few minutes. But really, if it's a tribal domestic violence court, as the guide sets out that definition, it puts the focus, all the protocols, all the hearings, put focus on victim safety. The protocols keep victims informed of the court process, exactly where the case is, exactly when the next hearing is, and it links victims with the advocate immediately. That's so important. Immediately after the case has been screened and identified as a domestic violence case, there is immediate link to the victim advocate to start safety planning. And I think because the victim advocate plays such an important role in a tribal domestic violence court approach, this will empower tribal victim service providers who are often not recognized by courts as an important and in fact necessary party to the victim's safety. Also, a tribal domestic violence court puts focus on court safety. This is a time where the victim's going to be coming into the courthouse, exiting the courthouse. So there needs to be protocols put in place so that the court is a safe place for the victim and possibly her children. Also, it focuses on court safety by providing specially trained law enforcement personnel who are also attending the hearings. We might have specially trained bailiff to maintain law and order inside the courtroom. We might have additional security outside in the parking lot and in a separate waiting room for the victim that also has security and safety-driven measures to make sure she's safe there. And we also would be thinking about during the hearings that these particular courts are really emphasizing all the safety from the court clerk onto all court personnel as well. Next slide. Another earmark of a tribal domestic violence court is we're going to hold batterers accountable. That's one of the purposes of a tribal domestic violence court. When you have the opportunity between systems that are not communicating with one another, the batterer often finds that is a fertile ground for manipulating the systems one against the other. So the way that the domestic violence court will address this is through specially trained court personnel, specially trained law enforcement. We want to also build strong relationships with multiple service providers for the victim and her children, as well as the batterer too. The batterer is going to need some service providing. And we're going to really the guide really stresses this safe and effective way to share victim information in a way that doesn't put victims' safety at risk. One thing also is the domestic violence court may allow cross-pollination of batterer records, again, to close those gaps between systems that aren't communicating. For instance, if a batterer has been ordered to, by the tribal court, to attend a batterer intervention program and is only allowed so many absences, and the batterer either isn't attending or has exceeded the number of absences allowed, that service providing, the batterer intervention program, will report that to this court case team, who will in turn report it to the judge. So we're going to close down those opportunities for the batterer to really manipulate systems against one another. It also allows the specialized court to determine culturally appropriate batterer programs, to focus on post-adjudication batterer accountability, making sure that batterer is really following and adhering to the letter of the tribal court order. And also, there will be built-in review hearings so that the judge can really sort of keep the judge's finger on the pulse of what issues is the victim facing, what difficulties is she having, is the batterer complying with the court orders, and those types of things. Next slide. Okay, also, the final earmark here is promoting coordinated tribal community response to domestic violence. I think the consensus probably is for people who work in this field is it's going to take all of us. It's going to take every system firing on all cylinders to effectively reduce domestic violence today. And so one of the things the Tribal Domestic Violence Court focuses on, and again, there are guide exercises in the guide I mentioned earlier, create policies between these agencies that are working with the victim, with the children, and agree on protecting client information, agree on policies and protocols on how DV cases will be screened, how they will be referred to the court, all of those sorts of things. It also may provide for an opportunity for regular meetings, it should, between these service providers, so they're all informed. When there's turnover, the new people are brought up to date. Again, they have written policies in place they can review. It also creates an environment in which system change can be achieved. If something's not working, we would hope that all of these service providers in this multidisciplinary approach, we're going to talk more about that in just a few minutes, that they will get together and identify gaps and barriers and work towards creating a maneuver that will correct those. Next slide. And here, that brings us to this particular slide, this multidisciplinary approach, which is, I think, one of the promising practices in addressing domestic violence. And every tribe's different, so you'll have to decide if this is right for you. But the guide really goes into great detail about the multidisciplinary approach, and I want to break that down into two different areas for you today. The guide sets up a planning team. You will decide, the planning team will decide who's going to be a member, but it is a multidisciplinary group of people who are going to work through all the exercises in this guide together and to make a determination with respect to whether a tribal domestic violence court or docket is a good fit for your particular community. So that's the planning team, is one multidisciplinary approach to this. But also, if, for instance, that multidisciplinary planning team determines at the end of all these exercises in the guide that a tribal domestic violence court is what they want to go for, then they will assemble, and perhaps some of the members of the planning team will also be on the second team, a core case team that will actually attend court hearings, again, for every domestic violence case. So again, when we're talking about multidisciplinary, we're talking about this planning team, and we're also then, if there's going to be a tribal domestic violence court, there's also going to be that core case team. So what the MDT approach to domestic violence does is underscores the importance, again, of this multidisciplinary approach and interactions between all systems. It provides for sharing of information among the systems. And again, noting there's an exercise in the guide that really focuses on sharing that information in a safe way for the victim. It also promotes the establishment of a collaborative network of courts. All at the conclusion of all this, the court now is very aware of all of the service organizations, social services programs that the tribe has to offer, and also if there are gaps there, are those services available in the state? Next slide. So I wanted to, let me check my time, folks, because, okay, good. So I wanted to sort of give you an idea with respect to this multidisciplinary approach. And let's just, for purposes of this particular series of slides that follow, let's think that we're talking about that planning team that you want to put together and you want to work through this guide to make this determination for your tribe. So you would want to think about having court personnel on your planning team, and because we need those court personnel to understand the power and control dynamics that are involved in domestic violence cases and how those dynamics affect victim safety. We also need them to understand how critical it is to handle client information and client legal documents in a safe and confidential manner. My colleague Bonnie Claremont often offers up the statement at this point that victim safety is directly tied to victim confidentiality, to keeping that victim information protected. Also, court personnel will participate and collaborate in designing courtroom safety for themselves and for the court in general, and also be responsible for coming to the planning team meetings and presenting court personnel issues as they become relevant in the exercises. And one of the ongoing earmarks, again, of both a court and a docket is every single discipline has to commit to ongoing and regular training in the area of domestic violence, sexual assault, and stalking, as well as victim information safety issues. Next slide. I also want to, okay, let me take a second to talk about tribal judges, and if this is out of, whoops, we're going to talk about prosecutors. Well, let me back up and talk about judges really quickly, because I think it's important for everyone to understand. I get a lot of questions around this, so I want to take a moment to talk to you about it. And if we come across the slide, we can skip it if it's down later and I just got my slides out of order. Judges provide leadership in the tribal community. Often they do. And so we need a judge on the planning team. And the judge may say, well, look, I've got all these court hearings. My docket's really heavy. I don't know that I can make every planning team meeting. Well, that's fine. If the judge will commit to coming to the meetings that really focus on tribal court and judicial issues, I think that's better than no judge at all. And I think it's really critical to have a tribal judge be on the planning team in some way, because the judge also is going to have to commit to ongoing and regular training on domestic violence, sexual assault, and stalking. And if your judge refuses to join the planning team, I just offer that may not be the right judge to handle the domestic violence cases, because I think once judges really realize the power and control dynamics and the victim safety issues, they're going to want to be a part of that planning team. Also, we need the judges to agree. These are some things we want the judges to agree to apply tribal statutes. If you have a tribal judge that's sort of riding a circuit or coming into tribal court, not a member of the tribal community, we want the judges to go read the statutes, because that the tribal legislatures felt that was the will of the people, and it reflects customs and traditions. And so those tribal laws will vary from tribe to tribe. So that's very important. We need the judge to draft legal documents, in particular protection orders, clearly, to invoke tribal jurisdiction, tribal sovereignty, and as well as the Violence Against Women Act, VAWA 2013's full faith and credit provisions. And if the victim is requesting to also put the language in the tribal protection order that invokes the federal firearms protections. We want the tribal judge to participate and collaborate in safety protocols for the courtroom and court personnel. We want the tribal judge to commit to enforcing protection order violations in Indian country, to draft legal documents that they understand with the stroke of a pen. They are either making that victim safer or putting that victim in more danger. So we need them to understand the gravity of what their legal documents will do for this victim. And also to draft legal documents that reflect the severity of the crime, to make findings, and so that order might be used later if in federal sentencing enhancements, perhaps a habitual offender in a criminal case. We want the judge to be responsible for court accountability. The judge is making a commitment and making sure that everyone in the court is going to do their part, and we want the judge to be responsible for that, and again, the training. Next slide. Yeah, where are we going? To law enforcement? Okay, tribal prosecutors, good. Yeah, let's stick with tribal prosecutors, that's good. Tribal prosecutors, we want them to be trained. We want them to understand the power and control dynamics. This isn't just every criminal case. This criminal case is coming in already having some lethality issues, some safety issues. We want the prosecutor to treat these cases like that, and to understand and enforce victims' rights, if in fact the tribal code has those rights, to draft criminal no contact orders when a victim is requesting that, and to draft those criminal no contact orders in such a way that they meet VAWA 2013's definition of a protection order. We want the prosecutor to commit to prosecuting protection order violations in Indian country, and we want the tribal prosecutor to be accountable for the tribal prosecutor's office and their role in the tribal domestic violence court, and that ongoing and consistent training. Next slide. So I'm hoping you're getting by now that these would be some ideal core members of your case team. You could have more, but certainly we need some representation from these disciplines. For law enforcement, we want them to understand that as a first responder, they're setting the tone for that victim who's already in a state of trauma. We're setting the tone for their participation in the case against the perpetrator if it's going criminal. We want them to understand the power and control dynamics, and that perhaps when that officer arrives as a first responder on the scene, the offender is exhibiting some signals, some sort of signals. They seem harmless to the officer, but the officer is already trained on this and understands those might be sort of an unspoken way to let that victim know what she's in store for after law enforcement leaves. We need that training, and we need the law enforcement to understand how crucial that tribal victim advocate is. And that tribal victim advocate oftentimes is the sole individual that can get that victim the services she needs to begin her healing, and then in turn to be taking charge, utilizing her victim's rights to be engaged if there's a crime charged against the perpetrator. We want law enforcement to understand the jurisdictional maze of criminal jurisdiction in Indian country. It is complex. And also tribes now under VAWA 2013, tribes that meet certain federal mandates, Congress has loosened restrictions on a tribe's sovereignty to exercise criminal jurisdiction over crimes arising in Indian country committed by a non-Indian. Those restrictions were put in place in 1978 through a U.S. Supreme Court case. And tribes that can meet certain federal mandates now, Congress has said, can begin to once again start exercising criminal jurisdiction over non-Indians in 3 cases: domestic violence, dating violence, and violation of a protection order. Again, those tribes have to meet certain mandates. And understand and enforce tribal domestic violence statutes. Don't say, well, this is the way the state does it. Let's get the tribal laws out and let's enforce those laws as they are written. Next. We want law enforcement also to understand the importance of entering and enforcing tribal protection orders in the National Crime Information Center, or NCIC, and other crime database systems. And this is critical. Many tribes cannot access NCIC to enter their tribal protection orders into this federal system. And what that federal system does is, when law enforcement arrives at the scene at 2 a.m., they're able to actually get into the database and verify that a protection order is it's in the system and it is still it has not expired. Let's put it that way. So the officers need to be able to have that. Tribes need access to that. So if your tribe doesn't have access to that, we need you to figure out why, work through these exercises, develop a plan to get those tribal protection orders in a national criminal database. Understand the importance of regular ongoing training in how to investigate these particular types of cases. Work collaboratively with other partners. Be responsible for their role in the tribal domestic violence court. Send people to court when you're called to do so. And again, attend ongoing and consistent training in the areas. Next slide. Tribal victim advocates, again, one of the cornerstones to making the multidisciplinary approach work, whether you're talking about the planning team, and we need your commitment to work through these exercises and work through all of this with us as a planning team, or whether we're talking about the core case team that is operating in a tribal domestic violence court. Advocates play a critical role. We need those advocates to understand the power and control dynamics of domestic violence and the victim safety issues. We need the advocates continually safety planning for both the victim and the children, coordinating available resources and services that the victim and children might need. Be a community educator. Teach your tribal community about these dynamics and the dangers of domestic violence. Be a community educator on lethality measures. There's a whole separate document. An example is Jackie Campbell's lethality assessment. You can Google that, bring it up, where an advocate who has been trained to fill that out can actually, it's not an exact science, folks, but can actually get a picture of the potential lethality of a DV case. And that sort of keeps everybody on the same page with respect to safety. I would expect that this advocate also would work on all safety plans for all partners, including the court, work collaboratively with the partners, accountable for their role. If it's a tribal domestic violence court or docket, really the advocate needs to be there, and commit to ongoing and consistent training. Next slide. Other victim service providers to identify who they are by this planning team. We want them to be trained on all of these issues that are listed here. As you know, and some of these are very similar to every single discipline. You could see that training is a central concern. I also, though, want to also mention in particular defense attorneys. And those, I mean, you might say, well, why would we want a defense attorney on our planning team? Well, I think the defense attorney's role is important because one piece of this guide at the very beginning of the guide is an educational piece on getting everyone on the same page with respect to this power and control dynamic and victim safety issues and victim service needs. And so getting that defense attorney involved and understanding the power and control dynamics of domestic violence is crucial, because that defense attorney, we would think by the nature of the discipline, is going to be working with perpetrators. So we want the defense attorney going in, educating on the power and control dynamics that can be recognized in perpetrator behavior. We also want the defense attorney to understand the danger of these cases. Victim safety is always at risk at every single maneuver, every single court order, and we want the defense attorney to know that and to be aware of the safety issues. I think defense attorneys also bring a unique piece to the case to promote batterer compliance with court orders by really counseling the perpetrator what happens when you violate this and whether a particular act is a violation. So I think that's important for batterers to know that. And to promote batterer compliance on firearms prohibitions if there's a protection order that contains that language in it. The importance of following the commands of the tribal court. And one thing that defense attorneys are good at, and it might be their specialty, is providing people, all disciplines, with input on where the systemic weaknesses are with respect to defendants' due process rights, with respect to weaknesses perhaps in a tribal code. You will see the defense attorney standing up and making objections to statutes or practices that defense attorney feels is impairing or impeding with the defendant's due process rights. So that's important to know, because once that information is identified, the planning team can go back and close up gaps or strengthen those weaknesses. Next slide. So now that was a tribal domestic violence court. We talked about a multidisciplinary approach by the planning team working through the guide, and perhaps by, if you decide a tribal domestic violence court's the way you want to go, by that core case team that's going into every single hearing. So now let's take a moment. Let's say you've worked through the exercises and you're thinking maybe a docket might be the best way for your tribe to go. So let's move the slide along. The tribal docket, just like the court, can be anything you want it to be. Here, just protection orders. It would be a particular day of the week or of the month, depending on how many DV cases you have before your tribal judge. And on that day, that court will hear all civil cases that involve domestic violence. Maybe you just say, okay, we'll start small. We'll only do protection orders, civil protection orders. So you design your docket that way. Or you might say, okay, we've been up and running a while. We've got a good planning team. We're all into this. We're working through the exercises, and we think we want all cases that involve DV to be before this one judge, the court personnel that are well-trained, and law enforcement's there. We've got added security there. We're focusing on victim safety, batterer accountability, and again, it may enhance relationships with the service providers themselves as they all get on the same page with respect to victim safety and batterer accountability. Next slide. Now we've talked about core values. We visited some in the tribal domestic violence court. We're going to just briefly touch on them again here. This entire specialized court is going to be focused on victim safety, and it is victim driven. And what that means is it's driven by the needs, by the voice of the victim. So we would hope it would say early screening. Let's get the case screened, marked as a DV case, and get them hooked up with that advocate at the very beginning. Also, let's get all of our services together for the victim, for their children. Decide which tribal programs we have, which state programs we need to access, and let's start getting all of that together. As a matter of fact, I think when you work through some of the exercises here, you will end up with what would be at least a rough draft of a directory of victim and children's services and DV cases. Next slide. We want to keep the victim informed at all times so she knows exactly where her case is. Could be that the planning team or even the protocols that are developed, that they may say, well, we want the victim to do that, or we want the the court personnel to do it in this way. So you'll be thinking about those sorts of issues as you move through the guide. Schedule the cases punctually. These cases cannot keep dragging on. That causes so much trauma for the victim and the children. They effectively cannot get on with their lives. They're always on hold for these cases. So let's get them scheduled punctually and let's move them through at a pace that's safe. And again, to provide safe places for the victim in the courthouse. Now, let's go to the next slide. Again, we're talking about a docket here. We want offender accountability in the docket. What we would hope you could provide is one permanent judge. And this is the judge that maybe has been on the planning team, maybe the judge who, maybe you just have one judge, but the judge says, yes, this is a huge issue in our community. Let's do it. We want the same prosecutors. So the same judge, same prosecutors, same law enforcement. We want continual monitoring of that batterer and that batterer's compliance with tribal court orders. And we want to be creative in the monitoring techniques. For instance, I just had a discussion with one group working on these issues and working through the guide in a tribe that had determined their tribe was small enough, and the judge had made commands that the batterer could not come within so many feet or so many yards of the victim at any time. And the batterer began to want to show up at certain tribal events. And they were wondering, will that be enforced? And the community, the members on their team began to make reports about batterers appearing and refusal to leave because the victim was also there. So you can get your systems to monitor in ways that might be outside the box, but work in Indian country. Next slide. We also, if we have a docket, we also need that judicial leadership. We need our partnerships, and we need education and training for all. The big difference between a DV docket and a tribal DV court is that the court has that multidisciplinary core case team that is working with the victim and children, and they're appearing at every hearing. They're working with the batterer too oftentimes, and they're appearing at every hearing to make requests or recommendations to that tribal judge. Next slide. So now hopefully you have an overview of what a tribal DV court might look like, what a tribal DV docket might look like, and how important the multidisciplinary approach is going to be. And hopefully you've also taken note of how important and instrumental the guide is to your assembling a planning team and sort of working through these exercises to come up with your own unique tribal design. I want to tell you just some benefits of a tribal domestic violence court and then a tribal domestic violence docket. I think you will see in your tribal community, although you might see others as well. So I think you're going to see informed judicial decision making. No longer will you have an untrained tribal judge, untrained in the dynamics, power and control dynamics of domestic violence. You won't have that judge just haphazardly writing orders and not really thinking of the safety consequences. A very good intentioned judge might be compromising. In other words, writing orders and the judge is not mindful of the safety issues connected with the commands of the court. And also having that consistent presiding judge so the batterer can't manipulate the system, can no longer manipulate the judge. The judge is seeing the batterer every single time. And also it lessens the trauma a bit for the victim to come in knowing she doesn't have to tell the same story every single time. Okay, and then of course the highly trained judge and court staff. Next. Victim safety, we hope that's enhanced through the use of a tribal victim advocate that's connected with that victim at the first identification of the case as a DV case, enhanced courtroom safety protocols, and utilizing the important role if you have perhaps 2 courts working on particular issues, 2 different courts, maybe one in state, one in tribal, all working to address certain issues of the family, that those courts are communicating with one another, and the multidisciplinary linkage to service providers. That is a very rich benefit of a tribal domestic violence court. Next. We're going to have improved collaboration among these service providers, again, breaking down those silos. They're going to be communicating with one another, sharing information with one another in a safe way, and better accountability by ongoing monitoring of compliance of tribal court orders. So those would be some of the benefits of a tribal domestic violence court. Let's move on to the challenges of a tribal domestic violence court. Just a couple I jotted down here because I wanted you to be thinking about, well, what should we be, what will we need? What sorts of issues should we be concerned about? Next slide. Again, we talked about these, so let's go to the next slide. So here we go. Here are some of the potential challenges. You might find some of these same challenges if you want a tribal domestic violence docket instead of an entire court. But the very first thing is a huge safety issue. And Bonnie Claremont brought this up and brought it to all of our attentions. Do not place the burden for reporting violations that have to do with bad actions and compliance with tribal court orders. Don't put that burden on the victim. That is a huge safety issue. So there is an exercise in the guide that asks the planning team to go back and take a really good hard look at your tribal domestic violence codes or sexual assault, stalking codes, and do any of those statutes put the burden for reporting violations on a victim, because that really compromises victim safety. So you want to work towards that. You don't want to implement a tribal domestic violence court, again, with this core case team that's multidisciplinary, if all your service providers refuse to work together. If you cannot break down those barriers with respect to all the core values that we listed earlier, victim safety, victim driven, better accountability, multidisciplinary service providers. If you can't get them to agree to work together, you're going to have to work on that before you can move further, move any further. And again, to recognize that not all batterers will be able to safely reunify with the family. I think, people have trouble recognizing, I think advocates in particular might have trouble even thinking about a batterer reunifying with the family, because there's just so many danger issues, safety issues there. But the reality is in Indian country that sometimes the victim wants reunification. And if it's victim driven, she gets to have a say. And if she's wanting to reunite with the batterer and he's wanting to reunite with the family, to make sure that it is done to minimize danger issues as much as possible. And so people are going to have to be able to agree on that sometimes they may want to reunite, and if they're going to, we need to put safety protocols in place. Perhaps we need to monitor longer to make sure things are going okay and that it's done in a safe way. And all of your service providers, everyone on that planning team, if you're just working through the guide, everyone on the core case team, that's going to be, if you have a tribal domestic violence court, and the judge, the court personnel, the advocates, law enforcement, they all, even in a docket, a DV docket, need to recognize and agree that domestic violence cases are complex and they are dangerous. Because if they have the belief that it's all just a bunch of arguing and drama and it really isn't that dangerous, that's the wrong person to have in the group. Next slide. And I just want to go back, you don't have to switch the slides here. I just want you also to consider that one of the benefits of a tribal domestic violence court is a stronger working relationship between your systems. And you know right now, sitting there probably listening, whether your systems are working together well or not in a safe way for victims. But I also think that you need to be thinking about when your victims come in, whether it's a court, whether it's a docket, I don't know. But you need to be thinking about oftentimes the fact that oftentimes tribal victims prefer to come into tribal courts. And they do that for a variety of reasons. But most especially, I think it has to do with historical trauma, the way they have been treated by the federal system, perhaps the state system, based on historical events. They want to come into tribal court. The trust is there. And they also are thinking perhaps they don't have to explain their belief system, their child raising beliefs. They don't have to explain that in their own tribal community. So tribal courts are going to be instrumental in addressing these domestic violence issues. And a good way, again, to do it is thinking about a DV court or docket. So let's move on to the docket here. You've decided, let's say, or you're still undecided about whether a DV court docket or a DV court is really best for your community. So here are the principles that really drive a tribal domestic violence docket. And this information is actually taken from one of the handouts, the fact sheets that we also provided to you along with the presentation today. So a lot of these are going to be the same as the tribal domestic violence court: the safety, victims being informed, the batter accountability, coordinating amongst systems, training and education. We've got a judge that's trained. Next slide. We have a court, even though it's one docket day, that on that particular docket day, the court can address victim safety issues by sort of on that particular docket day, engaging in more aggressive security protocols. The judge can address all of these issues on the same day, and that provides some continuity. Again, same judge, even if it's a docket, continuity to the victim, and allowing the judge to observe and address perpetrator behavior in the court. The court can also assign domestic violence court personnel to attend court, and require that could be the victim advocate, possibly even other service providers, to attend the docket to meet the victim's needs. So while it's certainly not that core case team, that rich multidisciplinary team that we're going to see in a tribal domestic violence court, you can see that this is focused on victim safety and batter accountability and what's best for the victim to meet the victim's needs in a safe way. So those would be the benefits of a tribal domestic violence docket. Couple more. Next slide, please. We're going to get some multidisciplinary collaboration, although it's not going to be to the level as a tribal domestic violence court. We're going to have ongoing training for key folks. These are challenges. And the multidisciplinary challenge, that's going to be the exact same. Can you get the disciplines to commit? Can you get them to work with you on developing protocols? Getting folks busy, overworked folks to commit to attend the planning meetings if you're putting together your planning team, to commit to ongoing training, to have this specialized court or docket, to funding and staffing for court personnel, space and location. Where can the victim wait in a safe way, get to the court, get back, leaving the court in a safe way, and technology and IT needs that might go along with this enhanced safety protocols. Next slide. The role of tribal custom and tradition, again, this is so critical for tribes when they're designing either a court or a docket to address domestic violence. Again, this is probably directly connected to the longevity and of the court or docket, and also tribal community buy-in, which is incredibly important if you want this to be accepted by the tribal community. So There are some core values listed here. We know that domestic violence, that the value of the court is to provide victims of domestic violence safety, continuity, protection, batterer accountability. We know that at least in most tribes, and again, there's an exercise you're going to go back and reflect on your customs and traditions, but typically violence against family members was not keeping with tribal customs and traditions. Oftentimes in some tribes, women were viewed as sacred, children were sacred. Victims of domestic violence deserve tribally based, fair, compassionate, prompt responses to the domestic violence, including valuing the tribal belief system. We know, it's proven, domestic violence threatens the political integrity of the tribe. Look at the tribal data, violence against Native women, and we know that it goes along, it's a responsibility that goes along with tribal sovereignty to keep victims safe and to address the issue. Tribal nations have the power to utilize criminal and civil jurisdiction. That's tribal judicial sovereignty. I mentioned at the very beginning of the slideshow, in setting standards of behavior within the family that are consistent and acceptable by tribal custom and tradition. And the tribe may utilize its tribal judicial authority to impose sanctions for offenders who violate those acceptable standards. Next slide. The safety and well-being of victims of DV and their children is critical to the strength and stability of the tribes. Victims often prefer to seek help from and utilize tribal systems over state and federal systems. Again, I mentioned this earlier, due to the mistrust issue, fueled by years of oppression, historical trauma, and a lack of oftentimes similar belief systems with respect to custom and tradition, and to protect the mother-child bond. Next slide. I wanted to, before we move into additional resources, I really wanted just to give you a little flavor of what one of the exercises, just a sample of one, and it's really a portion of a sample of one of the exercises in the Tribal Domestic Violence Court Docket Guide that I've been mentioning. And I'll just run these past you just for example purposes. For instance, one of the exercises, and this one really is focused on incorporating tribal custom and tradition into either a tribal domestic violence court or tribal domestic violence docket. Here are some of the questions, just to give you an idea. What are some traditional beliefs relative to keeping women and children safe from batterers? Now, envision this, the planning team, the multidisciplinary planning team, sitting around the table, and they're really digging into, maybe they want to invite some elders to come and talk about this. How did the traditional practices keep the family in harmony? Please provide stories or examples if helpful to others. Are these traditional practices currently in place, either by tribal government mandate, tribal law, tribal code, or practices of the tribal court? Second question. How might traditional beliefs or practices be implemented to achieve victim and children's safety and batterer accountability in a domestic violence case? Are there pieces of this history from the past you can bring forward and actually incorporate into the court's practice or into tribal code? For example, is it appropriate to incorporate some traditional insights into the tribal code itself, so that your tribal judge can reflect back on the purpose the tribal legislature was trying to achieve in enacting the statute? Is it appropriate for the tribal judge to request traditional insights? Perhaps if you have a tribal judge who's not a member of the tribal community or didn't grow up in the tribal community, is it possible to assemble a small group of elders who could, when called upon by the tribal judge, inform the tribal judge about custom and traditional practice with respect to family harmony, family safety? And with that, I'm going to turn it over to, I think, Chia, to go over the additional resources.
Great, thanks, Kelly. We just wanted to run through a couple of resources that you all can take a look at online. Next slide, please. So here are 3 of our tribal legal code resources that might be of interest to you all. The one in the middle, the blue one, is what Kelly mentioned throughout the presentation, the Tribal Domestic Violence Courts and Tribal Domestic Violence Docket Guide for Development of a Tribal Victim-Centered Specialized Court or Docket to more effectively address domestic violence cases. And we did include the link there. It's quite big, so we didn't have it in a PDF to send to you all, but you can download it for free there. And we also have our Tribal Legal Code resource that focuses on the Tribal Law and Order Act Enhanced Sentencing and the VAWA Special Domestic Violence Criminal Jurisdiction over Non-Indians. And there are significant overlap in some of the requirements, which is why we included those 2 statutes together in that book. And then we also have one on domestic violence law. So again, all 3 of these are available on the home.tlpi.org website, and they are available to download for free. Next slide, please. And here's a link to our website, tribalprotectionorder.org. So if you all want to take a look, there's just some examples and tips for drafting protection orders, enforcing them, and various resources. So I encourage you all to take a look at that when you get a chance. Next slide, please. And here are some more resources from our partner, the National Congress of American Indians, who is the lead TA provider for the VAWA Special Domestic Violence Criminal Jurisdiction. And if you look at their website, there's a great number of resources there. And if you're interested in joining the Intertribal Working Group on the VAWA Special Domestic Violence Criminal Jurisdiction, there's information on the website on how to join that group as well, which meets a couple times a year. It's a peer-to-peer support working group with TA providers that help bring information out to tribes, what they're interested in, and for folks that have implemented and those who are interested in implementing the law. And there is a pilot project report and a 5-year report, and they are available on our website and the NCAI website as well. Next slide, please. And here are just some more publications and resources that may be of interest to you. And all of these can be downloaded for free except for the Sharing Our Stories of Survival. And so these resources can be found at the Tribal Court Clearinghouse, and we have the www.tlpi.org, or else the home webpage that I mentioned before. And again, the Tribal Protection Order resources at the website listed. And then we also have a number of resources on sex trafficking, which can be found at tribaltrafficking.org. Next slide, please. So that's it on additional resources that we have. And if you have any questions, you can email Kelly. And I'm going to turn it over to Lana and Abby at this point.
Thank you, Chia. Thank you, Kelly. So we wanted to open it up for folks on the line. We have not received any questions, but if you do have questions, you can post them in the chat box, or you can email Kelly directly at kelly@tlpi.org, and we'll just monitor the questions just for the next couple of slides. So additional resources for this specific project, strengthening tribal response to violence against Native women, you can visit our website, which is www.tribalresponse.org. So these resources are available for tribes to download, including many of the resources that Chia had just covered and went over. We have located on our website. You can also find copies of additional materials, such as the tribal code drafting for domestic violence, sexual assault response teams, also included on there for download, as well as information to request training and technical assistance. So if you visit our website, you can request training and technical assistance directly from there, or you can email us at tribalresponse@tlpi.org, or directly Lana Hunter, myself, or Bonnie Claremont. Our information is included, or you can call us at the number located on the screen. So this is free training and technical assistance to tribes who do not currently receive Office on Violence Against Women funding. So I believe we have no further questions for you, Kelly, but I want to thank you and give you a big thanks for presenting the materials today for participants. And Chia, thank you for assisting with this webinar. And if you have any additional questions, you can contact Kelly directly or contact our project specifically to request training and technical assistance. Thank you for joining us today, and have a great day.